Hello and welcome to the ABLA Christmas Special. My name is Julian Arndt. I'm a director in our North Sydney office, Sydney office. With me is my Melbourne colleague, Tamsin Lawrence. How are you?
I'm very well. Thanks for having me, Jules. It's great to be back.
Christmas specials or festive specials, depending on what you prefer. I know this is a hugely early crow on this. It's so early, but in HR, in IR, in workplace law, we like to get organised. And so we're going to be bringing you a range of things today. The subtitle is Work Trends, Parties and Shutdowns. They're all going to come to us very, very soon. So let's talk about what we're going to be talking about today.
Absolutely, let's get cracking. So today we're going to cover three things, as you mentioned, Jules. We're going to kick off with looking at some current work trends. So everything from quiet quitting, remote work rollbacks, bare minimum Mondays and everything in between, all these kind of buzzwords that have been going around. We've been getting quite a few questions about. We're then going to look at the party season, everything you need to do into the lead up to Christmas. How do you prepare for your Christmas party? We assume most people might be locking them in now, but what are those precautionary steps you can put in place to make sure it's a fun one, but also a safe one? And then leave and shutdown issues. Hopefully some people will be aware there's been some changes definitely in the award space and some notification dates that are coming up very shortly. So we'll also touch on those.
Those who are aware of that are very aware.
That's true.
Just maybe piecing these three topics together, Tamsin, before we kick off.
Yeah.
I mean, what we're trying to do in the second last webinar of the year is really trying to take the temperature of the season, what's coming up for the end of the year, but also what's happening now. The new year, Christmas is a time where people start to think about jobs, what they're doing in their life, and very much this is where we kind of get to hashtag work trends.
Absolutely.
And so we thought it's a good time because we do get heaps of questions on this.
Yeah.
It's on certain news websites' front page every other day, the latest new trends. So we thought we'd drop this in and talk about, I guess, the fair work, industrial relations, employment law aspects of the buzzwords that are going on social media.
Yep. Shall we get cracking?
Let's do it.
All right. My favourite side of the bunch.
Yeah.
These is only a handful of the work trends that are apparently going around. If anyone's on TikTok or Instagram or even Twitter, although now it's X, I think, you might have heard some of these terms before. So we have the bare minimum Mondays, quiet quitting, acting your wage, snail girl. I think it used to be lazy girl and now it's become snail girl.
I don't know why they're always gendered. It's quite sinister, but in any case, resentful remainders is something you probably haven't seen on X or TikTok yet.
No.
It's a bit of a Julian Art special, that one, but we'll explain it to you and hopefully it'll go viral like these webinars do on YouTube. Like and subscribe if you haven't already. And then we're going to talk about something perhaps a bit more serious, remote work rollbacks, which is, I guess, we did have a pandemic and a lot of people worked from home for a lot of time, and Tamsin, you were in Victoria where that was a real thing.
There was no choice.
There was no choice. Remote work rollbacks it's an ongoing story, which again we need to tap into. Do we want to explain what some of these terms mean? Tamsin, you are a TikTok user. I am not.
I am. I must admit, I've seen lots of these trends. I think I've been targeted a little bit by the algorithm.
They're of a kind. Some of them are very similar to others. Some of them are slightly variations on a theme. But what are we looking at here when we talk about these work trends?
Well, the bare minimum Monday, quiet quitting, maybe act your wage, we'll maybe group those all together. They're all about doing the bare minimum of your job. So the essentials of everything everyone's required to do in their contract is what's done, but that is all that's done. So no extra, no helping out a junior learn something, no going to the work social functions, no doing that extra little bit to kind of secure the client. It's just doing the absolute minimum and that's all.
I want to ask or maybe say two things about this. For many of our viewers, doing what you're meant to do within your job descriptions, particularly in the sort of non-professional white-collar setting, is exactly normal and it's expected, and that's kind of how the workplace runs. This is really a professionals phenomenon, isn't it?
Yeah, but white-collar type
Yep.
trend, I think you could call it. Anyone who's in an office environment, this is where this is coming up. And I think it's really about saying, maybe it's a pushback on the corporate move and the idea that maybe people need a better work-life balance. They don't want to be doing all this extra stuff and not getting paid for it. That's definitely the trend, I think, of snail girl. I think that's really one that's about getting that balance and that lifestyle back. perhaps not the same for resentful remainer. Do you want to touch on that, or do you want to come back to that a little bit later?
Maybe we can touch on it a bit later. I mean, the thing I am interested in Snail Girl or Bare Minimum Mondays is that these aren't reactions to sort of evil corporate overlords. They really seem more about self-care and particularly young people, and we might talk about young people and how localized this is to young people. But this is about employee self-care. Obviously, we live in an era with a great emphasis on mental health, a great emphasis on balance, not a supreme focus of climbing the corporate ladder with a 9-to-5 job that you're going to be working for the next 70 years until your retirement gold watch. So that's the kind of vibe we're looking at as these various trends come up. I don't think this is just a media beat up. I think there are real people subscribing to these trends. This is real behaviours. And I can't see anyone nodding because I'm looking at a camera, but I'm pretty sure through the screen there will be people nodding and saying, I have people in my organisation, including possibly some young people on TikTok who are exhibiting these behaviours.
Yeah. And we've seen the questions that people have come to us with.
Correct.
I think. And they've said, we've got this employee. We'll get to an example, I think, a little bit later, but it's definitely something that people have raised with us and said, how can I address this? What do I do? So shall we just look a little bit further into the trends and kind of their use, and then we'll get into an example?
I think, and we've covered most of this slide already. It's interesting and it's amazing how quickly the world moves. I mean, March 2022 doesn't seem that long ago. It seems that quiet quitting has been around for a lot longer than that. But as we've said, I see this out in the industry of people saying, I don't necessarily want to quit now. I'm not going to loud quit. I'm not going to resign. But what I'm going to do is basically I'm going to withdraw my discretionary effort. And look, the terms haven't been given entirely negative connotations either, because I think there is some positivity around the primacy of the individual health and care and not sacrificing yourself for the corporate ideal. And that's how these ideas are sold. Now, this is all very fun to talk about. There are some real industrial employment law ramifications to this, and we will talk about them very shortly.
Can I just ask before we get there, though, do you think this is just something of the younger generation, or do you think we've seen some of this coming up with some older type workers, not to classify people by age? But
look, I think if you are younger, you're much more likely to be on TikTok or social media, and you're much more likely to brand your behaviour in this type of way. I don't think this is a young person phenomenon, and I actually do think just like every generation thinks they invent certain things, this is one of these things that the young generation think they invented. People have been deciding I'm only going to be doing the bare minimum in my job for as long as there's been jobs. And certainly this isn't a young person exclusive phenomenon, and it certainly shouldn't be used as a cudgel to hit the Gen. What are we talking? Gen Z?
Gen Z, yeah. I think they're the ones who perhaps have been unfairly targeted with this, but I think they're the ones who are putting it the most on TikTok and on social media. And to that end, it's every chance somebody online who's watching might have actually had this happen. You've turned on social media and you've seen your own employee saying that they're quiet quitting or doing bare minimum Mondays.
Which is possibly a question that we should get to in the questions.
Yes, absolutely. So let's move to the next slide, which is our example that we've perhaps recently had but rebranded a little bit so that we're not outing anyone in particular.
It's not actually that far away from what we received. Dear Tamsin and Jules, 18 months ago, we hired a fantastic employee in the product development team. For the first 12 months, the employee went the extra mile, often working late, spending considerable time mentoring, writing up complex pitches on the weekend, actively involving organising and attending after-work drinks, and volunteering for the company's PR events. This sounds awesome. This sounds a
give them a raise.
Gun employee. Around July this year, things drastically changed. It's clear the employee has really pulled back, simply working the contractual minimal hours, consistently saying no, stop mentoring young workers, and won't do anything outside of work hours unless directed to do so. other young staff are starting to follow in their footsteps. We need to do something. But the moment the employee's doing enough to comply with their contract, please help. Please help.
It's a tough one, Jules. It's very tough because as you mentioned, the person's already complying with their contractual requirements at the moment. They're complying with the policies, but it's pretty clear they've either been seeing some good TikTok videos or they've had a change of heart about what they're willing to give to their job.
I want to make one comment about this scenario and then I want to go to the next slide. This, in the absence of hashtags and TikTok, is just a disengaged employee, and employees have become disengaged for as long as there's been jobs. What's, I guess, different about this is that there seems to be a bit of a movement, and the intentionality of the movement where it's not just someone, it's just not, it's not an individual saying, actually, I don't like this anymore, I'm just going to check out. It's, you're part of a broader cause, I guess. What do we do? What can we do? Please help, Tamsin and Jules. I think the first thing you should look at as an employer in this scenario is the mirror. And what I mean is it really is up to you as the manager to try and fix this scenario. And it really is up to you as the manager to work out whether it is your fault, whether the employee has become disengaged and the employee has gone from an A++, kicking every goal, doing everything required and more, to a person who only does the minimum. It's very likely, in my experience, that it probably is the manager's fault.
Yeah, they're probably not feeling valued, not feeling like their extra contributions are being recognised, perhaps, or...
And this goes from real-time feedback. It goes from sometimes it can involve giving incentives, pay rises, and so forth. Just basically acknowledgement of the work effort. The first place to look is the mirror. Secondly, after that, if you look in the mirror and you say, well, I couldn't have done anything more, this is, I've done all we can. It's really not straightforward to performance manage these types of scenarios.
I was going to ask, because what are you using? The contract, that we assume they're complying with it. They're assuming they're not breaching any policies. So where do you get into that space of performance management?
It's very difficult. I mean, the touchstone of performance management is being able to place an employee's conduct against a set of rules, whether it be a policy or a contract, and basically hold them to account that they are required to do certain things and they haven't done them. In circumstances where they have done those things, there are limits to what you can do. The other aspect that's interesting about this is your use of PDs, or position descriptions, job descriptions. Very, very often employees don't have job descriptions or position descriptions. And I think the reason is that some employers say, well, we don't want to give them a list, because if you give them a list, that's all they'll do.
Absolutely.
Now, if you don't have a position description, it starts to get quite difficult to expect someone to do something beyond what they're currently doing if it's not in a contract position description or a policy. I would say, as it says on the slide, a reaction to say, well, if they're not going to show discretionary effort, let's just introduce position descriptions. Let's just pump up their position descriptions. It's a dangerous game to play. It's a double-edged sword, because what you'll end up with is they will only do that list of tasks or that list of duties, and you're not going to get your discretionary effort employee back.
And they might ask for remuneration for those extras, I suppose.
They may well. As ever, and I'll say this until I'm blue in the face, check your contracts, because the contract may allow you to vary their job or their duties in their job. I'm hoping it does, because if it doesn't, you've got another argument to have with the employee about it. I would say a lot of this can come down to the individual manager's skill in management, personal connection with that employee to try and understand why they've disengaged is going to be a much more effective tool than just a transactional management style, or firing off some directives by email, firing off some renewed policies, or even reissuing position descriptions and so forth. If you can kind of have that relationship level, if you can manage them, and who knows, maybe there's an issue in their personal life, which
I was going to say.
Yeah.
We're blaming it all on TikTok, but who knows? It could be.
Correct. Correct. It's not always social media's fault, despite what you hear. The other thing I would say is whether we're talking bare minimum Mondays, whether we're talking quiet quitting, whether we're talking snail girl era, I think these things are difficult to maintain indefinitely for employees for two reasons. One, I think hitting the precise bare minimum is difficult over a long period. I think eventually people will start to dip below. And then when they dip below, then you really do have performance management steps that you can take. Equally, look, people don't want to waste their time if they are unfulfilled, if they are doing something that is not rewarding to them, and if they are not putting their effort into it. It's difficult to do that forever in a lot of corporate environments. And as I said, we are kind of talking about the white collar scene.
It's hard to see doing this in a cafe or retail environment.
Correct, because you're on the tools, so to speak, and it's the bare minimum in a lot of those contexts is more than enough because they're physically demanding and quite stressful, busy jobs. So I think the most important thing is to keep calm with all of this. I think there's a tendency that I'm sensing out there in employer land that people can get a bit fixated on the TikTok trend and they can start to label their employees, oh, well, I'm sure that person's quite quit, and so I'm going to have to, isn't that typical of someone of that age? And let's try and bring the hammer down and try and performance manage them. Generally speaking, that's not a sound policy or practice. Get back to personal connection, relationship management rather than transactional management, and hopefully you can re-engage what was an outstanding employee.
Should we keep moving?
Let's do it.
Resentful remainers. Now, this is a term I'm going to give you credit for, Julian. I think you've coined this term, but it's something we think we might start to see in terms of the new flexible work request changes that have happened. Bearing in mind, flexible work requests have always existed, both in the discretionary sense and in the Fair Work Act sense. But we have recently seen some changes that we think might start to increase the prevalence of resentful remainers. Is that fair to say, Jules?
Yeah, so two things happened. Firstly, the pandemic happened and heaps of people went home. A lot of people didn't come back or have only come back in a limited way. Secondly, the first tranche of the Labor Party's reform,
Secure Jobs, Better Pay,
ding dong, has introduced an enforceable flexibility request right. Those, and it's a bit of a sort of bugbear's the wrong word, it's an interest of mine. Section 65 used to be a provision in the Fair Work Act which allowed people to ask, certain types of people, allowed people to ask for flexible arrangements. It, in a technical sense, wasn't necessarily enforceable because you couldn't bring litigation about it. The Fair Work couldn't decide whether an employer's refusal was reasonable from a flexible work request. That all changed, and that has changed, meaning that a range of people, parents with school-aged children, pregnant employees, over 55, 8 years of age, people with a disability, people who have experiencing family and domestic violence, can make a flexibility request of their employer, and there are now some procedural requirements about what you have to do. You have to respond within 21 days. You have to investigate and provide alternatives if you're going to refuse.
Yeah, and I think that's a big change that people need to know. It's not a yes and a no anymore. It's what else could I do to accommodate you even if I can't meet the exact specific request you've asked for. So I just flagged that because I think that in some inquiries that we've had to date, perhaps people haven't picked up on that change just
Correct.
yet.
Yeah, absolutely. Because the old system existed, but it wasn't really enforceable. And this we get the ability to contest. Now you can bring a Fair Work Commission claim to say the refusal on reasonable business grounds, which are pretty limited, wasn't reasonable. And I'm going to take you to the Fair Work Commission and actually contest this. That's changed the game. That's completely changed the game in terms of employers' obligations to actually think these things through and be accountable for their decisions. Now, we haven't seen a lot of cases in this space, I think mainly because a lot of people are still working in a hybrid way.
Yeah, I think a lot of people aren't refusing. Is that what you're saying?
Correct. And people, we're still managing through. People are still we're still kind of in the transition zone of how work is going to look going forward. But I will say this, and this is where I get to the slide. There is a group of people who didn't go home in COVID and perhaps had to come back a lot earlier than everyone else. And there is a group of people who cannot make flexibility requests because they don't have the various attributes. And there is a group of people who perhaps didn't move to regional Australia during COVID and are now working completely online. They are the people who are still in the office or are still, behind the counter or in the warehouse or wherever it is. I call these people, or I call a group of them, the resentful remainders, because increasingly we are seeing at a firm level those types of employees whose work practice and conditions and everything else are pretty much exactly as it was pre-COVID, looking at their other colleagues who are working from home or are working regionally or have a great deal of flexibility. And without good management, it's just a reality. Those employees are having to bear some cost, some burden for the fact that they are still on the tools, are still in the seat. And this is something that we really need to think about. Hasn't got TikTok traction yet.
Not yet.
I accept that. But please think about those staff members in your organisation who, for whatever reason, the nature of their role, the fact that they can't really move from that, the fact that they might live very close to the office, so the expectation is, that they can come in every day. If your policies do not think about the people who perhaps don't have the entitlement to flexibility enough, there is a prospect that they become resentful.
And it's also going to become difficult when you start granting other people whatever their flexibility request is. You've got to somehow make that up somewhere else potentially. And so usually that burden you'd assume is largely going to go on to those who remain in the workforce or who remain working full-time, for example, versus someone who might drop down a couple of days or change their working environment. And you've got to be very careful in terms of consistency, in terms of making sure that any changes you make are going to be sustainable in the long term.
Yeah.
And I think these are things that maybe perhaps prior to these secure jobs, better pay changes, it was just like, oh yeah, I'll grant you that, it'll all be fine. Given now employees have the right to challenge it, and I think once we do start to see employees successfully challenge, employees will be emboldened to start making these type of requests. Employers are going to have to be really careful and really process driven in terms of assessing these kinds of requests to ensure that, one, they can defend themselves if they do, whether it be reject the request or put forward an alternative that perhaps the employee doesn't take up. But also in terms of discrimination claims and other types of claims of that nature. And then you've got to deal with the resentful remainers and what the impact might be on them. So I think this is definitely a space where it used to be quite an open shut, pretty easy thing to deal with.
Yep.
But I would say definitely leading into next year, this is going to become a bigger problem for the employers that haven't planned it out and don't have a clear strategy for how to manage these kind of requests that come in. Particularly as well, I know you've touched on some of the procedural requirements, but there are quite a lot of things you have to put in the letters of response, for example, that employers need to follow. So a big recommendation, if you don't yet have that kind of procedure set down, take a few minutes before Christmas and make sure that if somebody does get a request and they're a manager, they're not just saying, yep, done, sure, you can work 3 days from home, not a problem. They're actually thinking about the impacts on others. We're treating everyone equally and we're going through a certain set process before we suddenly agree to allowing things to happen.
And certainly don't get that request and just say no.
Yes, another alternative. Yeah, absolutely.
Excellent.
Let's keep moving through. This is our very last one. Remote work rollbacks.
Yeah, so this is perfectly connected to what we were just talking about. There is a continuing discussion about getting employees back to work. The question that's sometimes asked, is it too late to even bother about this, is as the horse not only left the stable but the county. Look, it is still relevant that some organisations, including a very, 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 very large bank,
yes, my preferred bank actually,
is that right? I don't think you're allowed to do product placement here, but we have a situation where a very large bank mandated 50% office attendance, which for a lot of people listening will be not a massive request. That went down like a lead balloon, and disputes being raised. And there's two things I wanted to say about that scenario. One, That scenario, at least if you subscribe to the union view, is a failure of consultation. And we'll talk about consultation and getting the message across if you want to roll back remote work. And the other thing about that is these kinds of pressure points for those in the enterprise bargaining space will be used as leverage. You'll find these types of hybrid work, remote work, also right to disconnect, becoming enterprise agreement issues.
Yeah.
You're going to find them in logs of claims. And so those listeners in the union space, be prepared for the next bargaining round that you're going to have to deal with this concept of remote work and how much flexibility. And as Tamsin said excellently just before, it's about having a plan for how you're going to deal with any of this. Why I say it's not too late, or why I say these issues are, it's not over, is an amazing, in my view, study or survey. A big four accounting firm did a CEO
international wide,
more than 1,300 respondents, which for CEOs that's a very large sample size or a very large subject group. 2/3 of those CEOs said that hybrid work will end within 3 years.
Incredible statistic. I think we were just touching on this before we came on air. It's probably fair to say that the correspondence from management or CEOs around pulling back or dictating what days people are going to be in the office is perhaps the most controversial piece of communication we've seen in recent years. It's the one that really gets employees, gets their back up. You can't dictate this. And I think probably just a feature of people having such flexibility during COVID that they suddenly become this almost right that employees think that they incorrectly have. But it's definitely, I think this 2/3 suggestion by these CEOs is very optimistic.
I think it's optimistic, but I also think we're going to see some mandates and some directions coming through. If even half of those the CEO, it's the clues in the title. I mean, they're the ones going to be making the ultimate decision. We will see more firms mandating returns to work if that's the position of global CEOs, and that sample included Australian CEOs as well. What can you do? Can you actually do this? Look, contractually, check your contracts. Number 2, reference to checking your contracts. Check your contracts, what you can do. Prepare for flexibility requests once you make this request, because if I was, for instance, working from home full time and then I was mandated or directed to return to office in a scenario where I didn't really want to do that, I would think, well, can I make a flexibility request? And a lot of people can make flexibility requests. Prepare for those requests and then prepare for the claims if you refuse those requests. The last point, and I think you've just touched on it, policy implementation, mandate implementation needs to be very, very carefully and thoughtfully put through because, as you said, those are the emails, those are the directions that just they go viral, they go toxic, they go nuclear, they go everything because expectation management has directed or expectations of employees after a long period of very flexible work, they're going to have an expectation.
Do you technically have to consult? I know this has come up a few times. People have asked, do we need to? What's your take, Jules?
Yeah, I think probably yes, in a range of scenarios. I mean, the easiest ones is the cultural position. I think you probably do have to consult from a cultural perspective. Otherwise, you risk blowing up your entire workforce and their perception of their employer. From an industrial sense, I think it's highly likely that a modern award would require you to consult. There's an interesting argument about safety consultation. I mean, realistically, certainly you had to consult directing people home from a safety perspective because they were changing their workplace and they were going home and that needed to be safe. If you were bringing them back, potentially, look, all signs, all roads point to consulting very carefully in a considered way and understanding the consequences of what's going to happen when you direct people home or direct people back from home.
Absolutely. Well, I think that brings us to the end of part 1 of our webinar. Should we move on to the Christmas season? Because I'm sure there's lots of people planning their Christmas parties, picking their venues.
I hope so.
There's a lot to think about.
Yep.
Let's get into the party season. And it's fair to say this is a hilarious topic to discuss. There are some very, very entertaining cases. I know last time we met and we discussed this, Jules, we we went into quite a lot of detail about some of the more humorous cases. But I think as the Me Too movement, as Respect at Work's been rolled out, as we now have the positive duty on sexual harassment, I think the humour is coming off a little bit in this area, and it's becoming a little bit more serious. Is that fair to say, in terms of employer liability, in terms of getting your house in order, in terms of society and the court's expectations about what employers are liable for and what's okay to happen at a Christmas party? We're not, as I said earlier today, we're not in the 90s anymore. I think the argument used to be we're not in the 80s.
Yeah,
but
I remember when people used to say we're not in the 70s. But anyway, I think it's harder to be funny about this topic. I mean, there are, and we do training and we do these webinars and we provide advice. And look, some employee misconduct, it is very amusing. Unfortunately, there are in any workplace misconduct, there are risks taken, and then there are consequences, and some of those things, the consequences are not very nice for people, which is kind of the lens which, as you say, kind of tempers all of this. The new positive duty in relation to employers taking reasonable proportionate steps to eliminate sexual harassment, sex discrimination, and sex-based harassment. I mean, that really does raise the stakes for all of this. And anyone who's probably spoken to me, and know anyone who's spoken to you over the last more than a year, you will know that the positive duty, the fact that you are positively required to take steps to prevent those things, has changed the game. It's not about can we get away with it, and if there's an incident, were we negligent. It's about taking steps ahead of the.
So it never happens in the first place.
Exactly.
Let's keep rolling through and look at the big kind of issue in terms of employer liability here. When are you actually responsible for the conduct of your employees in terms of Christmas parties, in terms of that in-connection piece? I know you put up a few cases that we should perhaps just dive a little bit into.
Yeah, look, I'll pick and choose on this slide. I mean, I think that there's two things here. Obviously, work conduct at work is relevant from a disciplinary sense.
Yes.
When you do things at work, you can be, for want of a better word, punished for them if it's misconduct. There is another form of conduct which is clearly outside of work conduct, and that's not always irrelevant to workplace discipline, because where it's outside of work, there are established tests which say that if the conduct causes serious damage to the employment relationship, or it damages the employer's reputation, or it's incompatible with the employee's duties as an employee, even outside of work conduct can be relevant for making employment decisions. I just want to say a couple of things about this subject. One, obviously the scope of what is work has extended because so many people work from home.
Yeah.
Secondly, so many people have devices with their work emails and so forth on them. I don't think it was really ever possible to claim that a Christmas party wasn't a work event.
No, that was always in.
And increasingly, and we'll touch on this in some of the cases, it's harder and harder and harder to say, particularly in the absence of sound HR hygiene, that an after party or an after event after a Christmas party wasn't.
Or even the after party.
Correct. So there's a bit of a spectrum here. I mean, I think that, and again, the positive duty interplays over all of this, because you really do have to identify the risks going forward, and it's saying, well, I can just shut my eyes and close my ears once it hits 9 p.m. is not really available.
Because I think in terms of this, we're talking about the in-connection. Would the employer be liable if something went wrong? But that doesn't change anything from a positive duty point of view.
Correct.
In terms of you never eliminated the risk in the first place, so therefore you're potentially, that question about reasonable and proportionate steps is still going to be in play.
Yep.
But definitely from a, not to use too legal of a term, but from a vicarious liability point of view, is the employer automatically liable for the conduct of the employee because it happened in connection with work, is definitely a space I would say that is still a little bit grey. Do you think that's fair to say?
Yeah, I think so. I mean, these are also fact dependent.
Yeah.
And so let's talk about the facts. Rose and Telstra is the seminal case. It's a wonderfully graphic case. There was a fight with two employees while they were on tour or on sort of work trip. Yeah, exactly. It involved one of the employees being jailed for 4 months, so a serious altercation with a stab wound, with glass and all. it was a case where the conduct was so extreme, even though it was clearly out of work. It was so extreme that there was a real question whether what is this conduct going to cause serious damage to the employment relationship? Does it damage the employer's reputation's interest? That's the seminal case. Paul Brown and Aristocrat, it's a massive stitch up because Tamsin's put this in the slide pack just because she wants me to tell you about the case.
Very humorous case.
It is. It's 2005. So I think what we might say about this is it demonstrates something about the changing of the times. Paul Brown had, it's disputed, but between 12 and 15 beers at the Christmas party. He went upstairs.
So he's not at the Christmas party at this point?
The Christmas party was over and he went upstairs at the pub. Christmas party's downstairs. He went upstairs. He was disorientated. He chose to relieve himself, urinating over the balcony onto his Christmas party colleagues down on the...
Enjoying their dinner, I believe.
There was also an altercation in the aftermath, which was quite serious as well. The reason I raised this case, one, because Tamsin clearly wanted me to recount those facts, is in 2005, that employee brought a case for unfair dismissal and said, well, it's out of work conduct and so I shouldn't be held liable for it. I should be reinstated. I don't think that would happen now.
No, I'm pretty sure this one's a clear in the...
Correct. I think that the tide has turned. I think it's changed. That kind of behaviour very clearly, and I don't think that case is even run now. Newton and Toll, this is a more recent case, but all I really wanted people to take from this is that it is possible for the Commission to decide that an altercation between two employees was out of work. So this altercation happened at a union conference, and it's got nothing to do with work. There were some issues in relation to the investigation of the fight, some dishonesty, a dismissal. The full bench found that you can't, it was an out of work scenario. You cannot rely on this, and you can't rely on the conduct that happened in the investigation. This was an unfair dismissal. So be careful. We're not saying all behaviour, regardless of whether it's in or out of work. We're saying the lens is increased, but you need to be careful because people still have personal lives beyond work.
Yeah, you still got to make that connection point. There has to be something,
yeah.
But it can be event after event subsequent to the initial one that perhaps you might host, which is a great lead into this next one about go and host a fun Christmas party, but that move towards saying that it needs to be safe, it needs to be respectful of people. You need to think about things like the venue, who's there, alcohol being served. This is all now on the radar. And we put up this case regarding Westpac, which is a recent unfair dismissal case where it started off at a sports bar. And I think this is probably the one case where the Commission should perhaps look at themselves, because they did comment on the fact that a sports bar perhaps wasn't a place. It could be a hostile work environment for women, apparently, which I thought was quite an interesting observation from the Commission, being a woman from Victoria. But putting that to one side, the case did comment on the fact that the individuals went off to an after party and then subsequent to that moved on to another bar, and it was found that behaviour was in connection with his work. But there was some interesting comments that we've put up from the Commission about the duty of Westpac as an employer to look after its people and to make sure after the conclusion of the event everyone got home safe, and they were foreshadowing the positive duty and what's actually required of employers when it comes to making sure that anything that they do host, that they've thought about the kind of the before and the after, is what I would say. So a good summary of it?
100%. Look, the party's not over, but the expectation will be that you host a less wild, more safe Christmas party than perhaps you might have done some decades or years ago. And from a personal point of view, it's probably not a lot to ask, realistically.
No. Now, touching on another one of your more favourite cases, Jules, do you want to go to this one? Or?
Oh, look, all I want to say about this is we talked about this last year. You kept it extremely stony, straight face as I went through. The reason why I put this up is because, yes, you've got Fair Work Commission risk. Yes, you've got positive duty risk. But the other risk you have if you put on a Christmas party which spirals out of control is that inevitably the IR press, such as it is, will pick it up. The Fair Work Commission will detail all the gory details of the misconduct and the event and
On the public record.
on the public record. You will have men like me and women like Tamsin sitting here talking about your case for years, and it will be in every HR update. It will be reported on because it's very clickable content. All you did was fail to plan a safe Christmas party. And then for years, people will be putting slides up saying, you know, the water was put on the floor and the soap and the tops were coming off and they're sliding on the floor. The kicker in all of this is that in a Fair Work Commission decision, inevitably the real boot is put in to the HR team. Absolutely. or to the management. How could they have let this happen? How did they not have the very relevant policies, procedures in place? So I just put that up there to remind people that this is more than just fair work risk. There's a real reputational risk, which you just don't want to go down in history, basically.
Both personally and company.
Correct.
Which is a great lead in to perhaps if there's one slide you're going to screenshot or take a photo of, this is the one to take it. This is looking at what are these reasonable and proportionate steps from a positive duty point of view when it comes to making sure you have a safe Christmas party, but also from a liability point of view, as we touched upon. You'll also need to show that you took reasonable steps in terms of addressing your vicarious liability should something happen. And it's fair to say this is the comprehensive list. Do your due diligence before you even set down your Christmas party. Think about your venue. I do think sports bars, I must say, are still in, despite the comments of the Commission about maybe then being a hostile workplace environment. I still think they're in, but don't go like one person did in one of my most famous sexual harassment cases and choose a topless venue. That's perhaps not a venue that would be very comfortable for, say, women to be at.
Or some men.
Or some men, absolutely. Think about the theme, think about the activities. Is it appropriate? Would everyone feel comfortable? Now we have the hostile workplace environment offence where we don't even need anybody to make a complaint. We just need for one gender or one sex, to not feel comfortable. You really do need to think, would everyone feel happy and comfortable in the work environment that I'm creating through my function? Alcohol, definitely fine to provide it. We're not saying don't provide alcohol. I think we're not that much of a fun police, but have a time limitation. When is it getting cut off? If you're serving large amounts of alcohol, make sure you've got food. Make sure there's clear start and end times for the entire function, really. Educate and reinforce expectation. Now, this is going to be different for every workplace. For some people, you might communicate very well through email and through resending your policies. For others, it might need to be brought up at the team meeting before the event. It might need to be, a personal reminder to people on their way out the door. Whatever works for your business, but definitely have that communication, set that expectation. Say to everyone, we're out to have fun, but we're not out to cross the line in terms of people's behaviour. And in terms of after parties, to the extent you can, do not sanction them, do not endorse after parties. Make sure it's a clear delineation of when the event you're hosting ends, and any decision anyone makes to go on and do other things is not sanctioned nor encouraged. And as a part of that, how do you get people home? Making sure that you either make sure you're hosting at a venue that's close to public transport so people can get home, or frankly just offering cab charges or saying you'll pay for Ubers or whatever it might need to be. And if you are away, think about accommodation. It's always a big red flag for me when people are staying together at accommodation, you've got alcohol and you've got festivities, and it could be as simple as putting people on different floors, if possible, or making sure their rooms are far apart enough.
Oh, I think that's a great list and well delivered. I mean, my theme on these issues is always, all of these things are little risks that we take in the workplace to engage with each other, to have fun. You just need to manage the risk in a way that gives some utility to the event. People do need to relax. People do, you want staff to communicate with each other beyond work, but you just need to plan it. And hopefully you've got a paper trail. You didn't talk about, or maybe you did, nominated staff members being a supervisor. My preference for that is it's very informal. Someone with the requisite degree of authority culturally in the group kind of knows that they just have to look after each other. And
there always is one,
yeah.
I must be honest, as a default. But also that's the person who is given full authority if something does start to go over the line, that they're emboldened to believe that they're okay to step in, be that active bystander and address things before they go too far.
Correct. Everyone has been in a situation where you can see the train wreck starting to happen, and good workmates, good friends try and stop their workmate or friend from ruining their
Upset
career and
them.
life by making a mistake.
But if someone does, should we go on? What do we do when someone does cross the line, Jules?
Look, it's a good question. The question of whether we investigate Christmas parties, staff parties, it's the same for any investigation. You need to make an assessment. What's the ongoing risk, I guess? And the golden question, which sounds very sort of weaselly, is what is it going to look like if I do nothing? Increasingly in 2023, it's going to look very bad. It's going to look very bad if you do nothing. And I think your catch cry is don't. What's your motto?
I always think don't use something as an excuse to do nothing. I think often people are like, oh, the police are handling it, or this person's looking into it, or the employees resigned from the business, or somebody's didn't want to make a formal complaint, and therefore we use those as excuses to say, oh well, I don't need to do anything further. This is all at hand. My belief is in the world of the new positive duty and this expectation that employers are going above and beyond, and as you say, it's going to look pretty bad if you don't do anything. There is always something you can do, whether it be reinforcing expectations afterwards, sitting down and getting people to apologise, maybe thinking, God, I maybe need to do training again with my staff. They clearly aren't aware of our expectations. There is always something that you can do.
Or have a relational conversation.
Correct.
And ask someone whether they're all right and tell someone to pull their heading perhaps. But certainly if there's a complaint, if there is any ongoing safety risk or if there's any misconduct behaviour, I would be investigating it. If it's a prominent or senior member of staff, I would definitely be getting external investigators to try and we'll talk about that as we get to the questions.
So definitely what happens in Vegas doesn't stay in Vegas.
Almost, well, it's rare. It's rare.
All right, last but definitely not least,
this is
the recent shutdown changes.
This is a pretty hot topic. It's
people are pretty irate about it.
Yeah, it's cooled a tiny bit. This relates to rules about shutdowns, and they're usually at Christmas, where basically the operation, the firm, the factory shuts down, and there's a period where no one's at work. There are new rules for 78 modern awards. I don't know them off the top of my head, the 78. So I'm entering my snail girl era. But so make sure you check your award. But 78 awards is a good proportion of the modern awards. Now, what this new provision requires is that there is a written notice requirement. So 28 days written notice needs to be provided before you can institute a shutdown. If you're requiring people to take leave, that requirement must be reasonable, and that's based on an individual level. There are situations where a requirement to take leave in a shutdown would be unreasonable, and so you need to make that assessment. But I think the big one, the thing that's caused a bit of a commotion is, yes, if people do not have enough leave to take leave during the shutdown, you could come to an agreement with them to take unpaid leave or maybe leave in advance. But if they don't agree to those things, they either need to work or they need to be paid during the shutdown. Now, there's a paradox there as to how you can work during a shutdown and why you would be paid during a shutdown. But that's the nature of the provisions. Please have a look at your award. You've got some personal connection to the timing of all this.
The 27th of November, which I'll remember burned into my memory as it is my birthday. Thank you for remembering, Jules. But that's the last day you have.
Assuming your shutdown starts on Christmas Day.
Correct. Yeah.
Anyway,
it may not.
We're getting quite close to this. And again, a bit like, and this is the theme of our little presentation here, we're trying to get ahead of the game. We're trying to plan for things. This is something you really do need to plan for because it's possible that the tried and tested shutdown arrangements that you used to engage in, just telling people, oh, as you all know, we shut down from mid-December to early January. Take your leave, you have to, and if you don't have any leave, you're on unpaid leave directed. It's not going to be compliant with a lot of the modern awards. So having a plan is really important. Having a policy is quite helpful because that can go and sort of influence whether it's a reasonable request or not. And it's always good to have something in your contract about these issues. If, for example, you do have a pretty stock standard shutdown period and you've got a contract that says we have a shutdown period of between this date and that date, you'll be expected to take your annual leave. That will make a direction to take annual leave much more reasonable. The other thing that you need to do in terms of planning and approving leave is making sure that for example, you don't approve someone to completely exhaust all of their leave in October when you know that you've got an annual leave shutdown coming, a Christmas shutdown coming up that you'll need them to use their leave. So it's basically having a bit of a plan.
Yeah, plan of attack, almost I think the common theme from today's presentation. So
questions. Now, we probably should have talked about the iPad, but because I know how loyal our viewers are, I know that everyone's been sending their questions. And I'm going to start with, because we've got 2 sets of iPads today, I'm going to start with these questions. This is a Christmas party bad behaviour question. What do I do when it is the directors who are the ringleaders of bad behaviour at the Christmas party? Now, as a director, I feel slightly compromised in answering this. Your turn. Please don't make it about me.
You've only performed very well at all Christmas parties I've been with you at, Jules, but you treat them the same as any other employee. I think the big mistake we see employers do is give a leave pass or say, oh, this policy doesn't apply because they're a director. You know, you've got to set that expectation that whatever your behavioural expectations are in your business, that everybody abides by that and nobody is, you know, a blind eye is not, we don't turn a blind eye to someone just because they're a director. So I'd say, one, you got to reset those expectations and maybe make that clear to directors going into this year's Christmas season that they'll be held to the same standard, and if they don't meet it, then there'll be repercussions for doing so. In terms of what you do if they do kind of cross the line, I think, as you mentioned earlier, it's got to go down that formal investigation path in terms of bringing in someone external to look at it and look at how you can improve the culture and perhaps take action against the employee for doing so. Obviously, that's particularly difficult if the director is the owner of the business.
Yeah.
I think that's perhaps a tough one, but from a HR perspective, I think that's when you've got to sit down and set down the legal liability that you're potentially facing, because it's not just about whether or not that person might personally be liable for what's happened, but whatever conduct they engage in, the employer themselves as an entity are potentially going to be liable, both from a vicarious liability point of view and from by the time we roll around to the Christmas party season, also from a positive duty point of view. So whilst I'm sure the director might want to have fun in his Christmas party, he might look at the risks and the financial risks of engaging in that behaviour and maybe have a second think about doing it this year.
Yeah, look, the other aspect of all of this is some of these scenarios are very difficult.
Oh, absolutely.
For HR. They just are. There are options. There is, hopefully there might be multiple directors. There may be a higher power aboard that you can go to. There may be external whistleblower type complaint scenarios that you can kind of go sort of remove it from the direct supervision of the director in charge. Advice is often useful on these types of issues, and we field a lot of calls just trying to talk through the problem. We've got this very important, powerful person who's done the wrong thing. We don't know what to do because we can't talk to them directly because we're worried we're going to lose our jobs. But the person who's making the complaint is in an unsafe position. It's difficult, but as Tamsin said, don't make something an excuse to do nothing. And how will it look if you do nothing? Very likely, very bad.
Absolutely.
Fabiana, we are going back to probably a quiet quitting scenario and an employee who's disengaged. Could a JD have a catch-all phrase, anything within the employee's skills, competence and training? I think so. I mean, you could definitely have that, and you see those kind of clauses in contracts a lot. Whether it would be precisely the right tool to kind of lever a quiet quitter or a bare minimum Monday participant back into full speed mode, I'm not sure, but certainly that would be a useful casual phrase. And look, that really gets to the difficulty in all of this, the double-edged sword. You do not want your job descriptions and your position descriptions to be all your employees do.
Yeah.
I mean, that's the whole problem with bare minimum Mondays or snail girl era or whatever you want to talk about. That's the whole problem, that it's a work to rule environment. You really do want to have a scenario where people are expending discretionary effort, because it's just a better performing workplace and more dynamic and rewarding workplace. So great question. Tamsin, Work health and safety legislation, sexual harassment at a work party, given a venue and a party host could be PCBUs under legislation, can you really investigate an incident pending a criminal court hearing?
It's a tough one, I must admit. And the issue with sexual harassment now, it's become a positive duty, is the expectation on investigation is both from a safety point of view and from an employment workplace relations point of view. And those types of investigations are also quite different. From an employer point of view, we're looking, can I take disciplinary action against the person? And from a safety point of view, you're looking at, what else is going to happen to somebody else in the future. I would think if you've got an ongoing criminal investigation, as I always say, it's not an excuse to do nothing. I think you can let that run and take the advice of the police in terms of what to do with the individual from an employment point of view. But from a safety point of view, there's definitely things you can do in terms of investigating, what risks were there that you didn't put in place control measures for? What can you do better in the future? And maybe it is even doing consultation with your employees to find out how this occurred. Now, that means you can keep that completely separate from the actual employee and whatever's going on criminally. But I definitely think from a safety point of view, you're obliged to look into the risks, look into the control measures and update whatever you've been doing. And that's definitely the obligation under work health and safety law, even without the positive duty in existence.
We've got some feedback on the line about the notification about Christmas shutdowns and about the various things that may be different in different modern awards. Check your award. Those 78 awards have been varied in a similar way, but absolutely don't take our word for it that your award is definitely in that group. Check your award to make sure you're complying, because some awards do have slightly different requirements, and you're going to need to.
And if you are confused, always reach out. I'm definitely happy to help if you do have any further questions or you're not clear with what's required if you're going into the end of the year.
Couple of questions we'll answer quickly. Do you view the bare minimum Mondays is comparable to the 4-day work week, a suitable alternative that provides workplace coverage while enabling greater flexibility? Interesting. I mean,
I think that's how the TikTok people would like to phrase it. More about lifestyle, getting that balance back.
The thing with the 4-day work week is that's a collab between your employer and your employee. The bare minimum Monday thing's an employee-directed thing, so I don't think it's the same thing. Although the proponents of bare minimum Mondays would say it has the same result: a more rested and productive employee.
Stop having the Sunday scaries, as they like to call it.
We're almost out of time. I just need to ventilate this question because it's giving me slight anxiety. What if they put you on notice that they're going to cross the line at the Christmas party? I
would cancel their invitation personally, but in what sense? Someone tells you I'm going to,
as in I'm going to have 12 to 15 beers tonight, and I'm going to create a menace of myself. These are the types of remember positive duty. These are the types of scenarios where you really do need to be quite dynamic in your management of things, absolutely. And those kind of comments, I would want something in writing to correct that kind of
absolutely. Resending them the policy, saying, look, that all sounds great, but these are the behavioural expectations we have of you. We want you to have fun, but it sounds like you're going to go over the edge.
Yeah, I would want to make sure it was a joke and possibly make sure that everyone else knew it was a joke.
Yeah.
Because we've all heard people say that Saturday night is going to be mental.
It's going to be big.
Look, that shouldn't really be happening in the work context in an unsafe way. So we're very close to the end, Tamsin. Do we have a final next step slide?
We have a little slide that tells you some of the things we can help you with that we've touched on today. That's probably a really good reminder about some of the things we've covered. So definitely first, flexible work requests. This is the one where things have changed quite a bit in terms of the obligations on employers in response. If you're sitting there thinking, haven't had one yet, but I'm a little bit concerned I might have one, and I don't have any plan of attack in place, we definitely have a checklist and template letters that kind of sets it out. You can give it to your HR team or use it yourself, whatever you need. If you need your policies and procedures reviewed coming into Christmas, let us know. I don't know how many times we've mentioned the sexual harassment positive duty guide and toolkit, but if you haven't yet had a demo or you're looking at down the barrel at December and that Human Rights Commission getting the power to come and look in your workplace and you think, I'm just not ready, I need more help?
If you do not know what Tamsin's talking about, please call us, because this is a serious thing that you need to take steps to address.
But that toolkit and guide can definitely help you. And in terms of online training, there is a little bit more to come, Jules, is that right?
There is employment law for managers, workplace investigation and sexual harassment in the workplace. This is the second last webinar of the year. I think we've got some of our colleagues getting the crystal ball out about what's 2024 is going to bring us. The 2024 training schedule is coming soon. Just email us with any questions. Tamsin, it has been a blast as always.
Thanks so much for staying with us.
Thank you so much. And if we don't see you, have a great Christmas.
Merry Christmas.